Commission. Is there anyone present, members of the public, who wish to make a comment on anything that is not on our agenda? Okay, nobody here. So we'll move right on to item 3A, which is a public hearing on item GLUA-19-00020, variance for retaining wall height in front of a building at 397 Warner Milling Road. And I get to read the script. Okay, we have a public hearing on land use application scheduled tonight. Our role is to conduct the public hearing and to make decisions about the matter before us. In making those decisions, we must apply the applicable codes and laws and not vary from or change those laws or codes. Members of the Planning Commission are to be unbiased. Before the start of the hearing, I will ask the commissioners whether they have any potential conflicts, such as family, financial, or business relationships with any of the applicants or with regard to the land in question. I'll also ask whether any of the commissions have discussed the application in question with any of the parties or have independent knowledge of relevant facts, such as from a visit to the site in question. Any member of the audience may question any commissioner about their disclosures. A staff report has been prepared for each application and has been made available to the public 7 days before the public hearing. The staff report identifies the approval criteria that apply to each applicant's proposal. Staff has analyzed the criteria which are contained in the staff report. The quasi-judicial hearing procedure that the Commission will follow is set out in state law and the Oregon City Municipal Code. Hearing procedure steps are shown in the chart on the wall. Anyone wishing to speak should fill out a speaker's card and give it to the planning staff before the hearing. Speakers will proceed in the order in which their card is received. You should fill out your address on the card so the city can notify you of its final decision. For the public record, please begin all testimony stating your name and city of residence. Testimony and evidence should be directed toward the applicable approval criteria. If you believe other criteria apply in addition to those addressed in the staff report, identify and discuss those criteria and explain how and why you believe they apply to the application under consideration. Any person may submit written material while the public record is open on each application. Any written materials received by the city staff during the time period in which the record is open will be placed in the record. Written materials submitted during the public hearing must be presented to the city staff in order to become part of the record. If a person intends for PowerPoint presentations, oversized poster boards, reports, pictures, or other exhibits used in their oral testimony to be placed in the record, copies must be submitted to the city staff while the record is open. If they're not given to staff, they will not be included in the record. Any person wishing a continuance to present additional evidence and testimony or to keep the record open to respond to new evidence must make that request before the public testimony portion of the hearing is closed. If the Planning Commission makes a decision with which you disagree, any issue that you may wish to appeal must have been raised on the record for the consideration of the City Commission or LUBA or both. Without raising the issue on the record with sufficient detail and accompanied by statements or evidence that the city and all parties can respond to, the issue will not be deemed appealable to the City Commission or the State Land Use Board of Appeals. In addition, the failure of an applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient detail to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. So now we will open the public record hearing for Oregon City file number GLUA-19-00020. And we'll start at the end with Mr. Mahoney. Any ex parte contacts or conflict of interest? And visit to the site?
Drive by every day.
Okay. Commissioner Johnson?
Pretty similar. I drive by it every day, but at 25, 30 miles an hour, even though there's a stoplight there, you think you can see stuff, but I took the opportunity to walk by. No other ex parte contact or interest.
Okay. Commissioner Stoll?
No ex parte contact. I made a site visit this evening.
Okay. Commissioner Guile?
I missed what you were reading. I was reading this. Could you read that again?
No. No. You can go stand in the hall and read it to yourself.
No ex parte, and I've been by there almost daily. That site.
Okay.
No ex parte contact, and I went and checked it out, and I wanted to see exactly what was going on there, and saw that the wall was there, so I've seen that.
Okay. Commissioner Gage?
No ex parte contact. I go by the site all the time.
Okay. And for me, no ex parte contacts and no conflict of interest, and I visited the site this evening, walked by it. Okay. So does anyone in the audience wish to question any of the commissioners about their statements? All right. We'll move on to the staff report. Ms. Reed?
Thank you, Chair Mitchell. I'm working on getting the screen up here.
Okay, everybody can turn back on their phones while she does that.
Angry Birds to finish.
Thanks. It was the mute button for some reason.
Living dangerous times.
All right, thank you.
I know, oh my God, it worked for a change.
So I have a staff report and recommendation for you tonight. As was mentioned earlier, you may have noticed that the retaining wall is already there. I will explain why during the staff report. So this application is a minor site plan design review with a variance for the height of the wall. The subject property is 397 Warner Milne Road on the corner of Malala and Warner Milne. The property had been undeveloped right next to an existing medical office building. In 2018, an application for another medical office building was submitted as a type 2 site plan design review. So it was staff level review. Last year, we approved the approximately 3,500 to 4,000 square foot building. And this was the initial application, the rendering from the initial application. So you can see the entrance was, the entrance is proposed at the street corner. And then in the view from southwest image there, you can see that farther down on Warner Milne, there were a few stairs to get up to the pedestrian circulation kind of system for the site. So that was the original plan with the building at sidewalk grade. Now, here's the original site plan and the building elevations. The building materials changed slightly after approval, and those were permitted building materials, and so we handled that through a staff level review as well. You can see along Malala here, there was landscaping proposed, then it had the entry here on the corner, and then another walkway connection from Warner Milne, and there were a few new parking spaces proposed as well, kind of just extending the existing parking lot right there. Now, the existing conditions of the site were that there's a small change in grade and elevation. So at the property line where the existing parking lot is, it's about 450 feet, and then up at sidewalk, it's about 456 feet. So there was some topography there. But again, the original proposal was the building to be at grade of the sidewalk, and then some stairs to make up the difference further down Warner Milne. Now, after land use approval, of course, we always know that there are some changes that happen. Sometimes that has to do with land use items, sometimes it doesn't. What happened in this situation is that the grading plan changed because the ADA parking was proposed on that far side of the building. And the grade needed to get from the ADA parking to the secondary entrance on that side of the building required a change in grade. So ADA parking was here, and then there's a secondary building entrance here. So the plan changed to lower the building so that they could make grade for the ADA entrance here. So the entire building then got lower. So the result of that, because it's so close up to the sidewalk, is that you have the building foundation kind of significantly below the sidewalk level. And so the building permits had been issued, the grading permits were issued by our Development Services Department, the building permits were issued by our building department. We realized that there would be some changes to the site. And then when we realized that the retaining wall was going to need to go in along here, where you see that big drop in grade, we were working with the applicant to get that approved at a staff level. But we realized that we do not measure the height of retaining walls the same way we measure the height of a building. We measure the height of a building from the sidewalk grade. So this building actually got shorter because it's now below sidewalk grade. We measure the retaining walls from the top of the wall to the bottom of the wall. So even though this wall is entirely below sidewalk grade, the 5 feet in height exceeded what is allowed in a front yard by our code. And so I show you these pictures because you can see that the earthwork had already begun when we notified the applicant that they would need to request a variance for this wall. And so some of that grading, they found things in the ground. I think it was a vault, had to excavate underneath the sidewalk. There were some safety issues. So as we worked with the applicant to get the variance process started, they requested, because the site was kind of in this condition, to go ahead and pour the wall. We consulted with our city engineer, who agreed that it was a safety issue to leave the site in this condition for more than a month. And who also said that in the interests of the traffic flow and the lane closures, that they should be allowed to pour the wall at that time instead of waiting until the Planning Commission approval. So that is why the wall is already there. And the applicant understood that it was their risk, that if this was not approved, then they would have to come up with a different solution. So we worked that out, and anyway, that's the explanation. Now, the wall itself is shown in this green line here. So it wraps around the front corner of the building on Malala and on Warder Milne. It's about 72 feet in length. And it starts out shorter, maybe around 2 feet on each end. And then as it goes closer to the corner, it gets taller. It's 5 feet tall for about 28 feet around the corner here. The wall is also, because of that large drop to the building entrance area, there's a 3.5 foot guardrail on top of the wall for safety purposes. So the actual height combined of the wall and the guardrail is 8.5 feet. So our supplemental zoning chapter 1754 includes the rules for height of fences and retaining walls. And front yards are limited to 3.5 feet in height. And so that's why we're here, the variance. The criteria for variance is that it's not likely to cause damage or have unmitigated impacts on adjacent properties, that it's the minimum variance that would alleviate the hardship, that it would equal or exceed the purpose of the regulation to be modified. Again, mitigation, impacts are mitigated, and that there are no practical alternatives, and that it conforms to our comprehensive plan. So I have findings in the staff report supporting all of these criteria. The key one here, I think, is that this wall is completely below sidewalk grade. It's minimally visible from the right-of-way and from adjacent properties. The way we measure that wall height is almost just a technicality that's requiring this variance. So we didn't think that any mitigation would be needed for this wall. So our recommendation is just approval with no conditions. And then the only other criteria that really apply to this are building material standards in our site plan design review chapter. And the wall is cast in place concrete. The railing is a steel metal railing, and both of those meet our building material standards. And so we recommend approval with no conditions.
That railing, is that, something that the city would have ordinarily put in for safety purposes?
I believe it is a requirement of our Development Services Department because it's so close, because that drop is so close to the public sidewalk.
As for traffic safety, in case somebody crashes, it's got that railing.
And for pedestrian safety, so if you're walking on the sidewalk, you're protected from falling down that 5-foot drop. Because this public sidewalk is here, the wall is very close to that, but not within the right of way at all. And then on the bottom of that wall is still the walkway to the building entrance. And then the walkway has actually, so the plans changed, not just the wall, but the landscaping plan changed a little bit clearly. And the pedestrian circulation plan changed. These were all things that we handled through the staff level review, however. So that's why I wasn't talking about them here. But the walkway goes around the building here, and then there's a few stairs to get up to the Malala sidewalk. So there's actually an additional way to get down now, instead of walking all the way to the corner as it was planned originally.
The expense of the railing is the applicant's.
Yes, I believe so.
Done a lot of thinking about this one, because I'm always negatively opposed to fences and the where you can see or come up to that light, and I don't want anything obstructing it. So I'm glad to see that it's 5 feet below. I wrote down the site condition frame that you had up there, the pictures. So that's 5 feet there at the corner where the 2x4s are. So the railing would be right above that. And the railing would be see-through. And I would have liked to have seen a picture of what the railing was gonna actually
so
look
it's
like.
on this page right here. It's just metal posts.
Okay, but I mean, again, you're coming up to that light, and I attended last week's city commission meeting where they're gonna redo Malala Avenue. And I'm not sure if it starts in that area or not, or if it's just a little bit beyond that. And my concern is doing things to Malala Avenue that can obstruct vision, because they're concerned about pedestrians and bikes and all that. And I thought, how clear are those gonna be in between those spokes there? I guess, is it say 4 feet max, or is that 4 feet to
inches.
height?
4 inches between
4
the,
inches. And again, I'm concerned if you're coming up to that light and it's green and you can't see around a 4-foot fence, because you're sitting in a car and it's usually lower than 4 feet. And so I've had major concerns about this, because that's a corner where accidents occur. And with having another fence around there or something else, I'm happy with the 5 feet, and I know you don't want people to fall in there. My concern is vision for traffic. Coming down Malala to turn onto Warner Millie, or Warner Millie to turn on, of being able to see through that very clearly.
that's a good question. Our Development Services Department does analysis for traffic site obstructions, and they've been involved in the permitting for this wall. There were stormwater items related to it, and the wall itself needed some Development Services review, along with the right-of-way, all the right-of-way improvements that they're making, new sidewalk and all that. So it's been looked at by our Development Services Department, and it's been approved.
How wide is the sidewalk at that point as it goes around there?
I believe
Wide.
that
You
it's
can
10,
see it.
the new sidewalk will be 10 feet.
I know, but from the fencing area, from the,
Well, you can see it.
The new sidewalk is gonna be 10 feet wide.
that's this line outside here. Is that right? I'm trying to
Here,
hard to,
this distance is
is
at
that the
least,
sidewalk right there?
yes, that's at least 10 feet.
But over on this side, it's not that small. I
Over
mean, it's
here.
not that large.
I believe this right here is still 10. I'm sure that's not actually gonna look exactly like that, but it'll
So
transition.
you brought up something you just said about runoff. Where does the runoff of this sidewalk go? Down inside this wall and into the building, or where does it go?
The applicant might be able to, answer that question, but, the Development Services Department reviewed all of this, including the original proposal for the building itself, and all of these changes have
But
been
the original
reviewed for-
building was changed. Did they notify you before they changed the level and all that? They just did it?
We're part of the review process, and I think it was just a timing issue with when the planning department was notified of the changes.
So
Dirk just brought up something, the green, is that planting along that green line? So there'll be something to, or is that the wall? I mean, something to soften it rather than you just have this railing and a drop off?
Yeah, so the green line is the wall, and in between the wall and the edge of the sidewalk, is just, like grass. So it'll be sidewalk grade and then a little bit of a slope with a grassy
Out to the
slope,
sidewalk?
and then the wall.
The slope is towards the wall, that's
It's
cement.
down, yeah.
Is that safe for people in wheelchairs that are coming around there? I mean, could they go and fall into that as it goes down?
I think it's a really short.
I'm trying to think of all the
slope, but-
things, because it's a corner on a
That-
major road.
that is a question that I wanted to bring up, and I wondered if that is covered in our code, because it's not really a narrow area, and it's quite a drop-off. So, to Tom's point, if somebody put a stroller, a wheelchair wheel off the edge, that's a pretty steep drop-off away from the sidewalk, and I don't know, does our code cover that kind of a situation? I'm sure that the decision was made on the height in order to minimize the height of the wall, but did we now leave too much of a drop to
Yeah.
cover in that planter?
Good, did you? Well, so all of the sidewalk improvements are kind of all related to this, right? Because we're widening the sidewalk. So our Development Services Department has approved it and reviewed it for safety.
But this doesn't answer my question or his. I mean, somebody's safety, is there gonna be like a curb along the sidewalk to stop somebody with a stroller or a wheelchair from accidentally tipping into that area?
I
By the
don't
stairs?
think there will be a curb, but the guardrail will protect
But
against
that's
the
after you
fall.
fall it down into the
Well,
brush.
So it's there's sidewalk and then maybe a foot of a little bit of slope,
Just a foot.
and then the retaining wall. Yeah, there's not a lot of space there. I mean, you can see right here at the corner, the wall's almost right up against the sidewalk. So this distance right here is 6 feet. That distance. So,
And
this
that's
is.
below the wall.
That's below the wall. So this is, maybe, no, right here is 6 feet, right here.
It's 6'6",
Right.
and it's stair steep.
That's
So-
about 4 feet.
But again, the grade, so the highest grade change is right at the
At
corner.
the corner, which is,
And so the distance is probably a foot or two,
Okay.
right between the wall and the sidewalk.
because it's on
and
a
then-
corner, that's my concern.
I have a legal question, I guess. I took a picture 20 minutes ago of exactly what we're talking about. What's the process of showing this to Laura
You
and Kelly
send
so
it-
they can address the,
You send it to
Question.
Kelly or to Laura, she prints it out and distributes it. Or she otherwise gets it up on the screen so that it becomes part of the record so that everyone can look at it.
Okay. Can I check for pictures too? I may have some.
Sure, everyone can check for pictures.
I've got some of Elvis, he was standing there.
I took some.
I just sent it, so why don't we do this? Why don't we move on,
And hear from the
hear from the
applicant.
applicant, and then in our discussion, we'll loop back and talk
Well,
about
I
that.
think the applicant ought to be able to see the pictures before you close the record. But other than that, no
Right.
problem.
And I'm sorry to be a stickler on that, but again, I sat through that whole presentation by John Lewis at last week's city commission, and they're talking about safety for pedestrians and bikers and all the things on Malala. While this may not be part of that, it's still Malala Avenue from down where the young lady got killed from down there all the way up. There's problems with pedestrians and things like that. And a corner lot like this, it just always concerns me when there's something that's in your view and when you're driving.
I have no pictures of that.
Sorry, just,
I would encourage the planning commission to sort of stay focused on what the variance is before you.
Right.
And when you start thinking of other things about what the building code is or what public works standards are, that's a bit out of the purview.
no, but if it's a variance, and I know that it's a problem in the future, that's to me a concern for any variance. It could be a safety thing, and why would I approve a variance if I don't think it's comfortable for pedestrians? That's what I'm at.
No, I appreciate that. What I'm saying is find a nexus to a variance criteria, and then we have to have findings why there is a nexus, and then you can do conditions
Nexus.
and things like that. So of the variance criteria, what is or is not being met? Kelly put together the staff report with recommendations and things like that. Which variance criteria do you believe is an issue in this stance? Also, as Kelly mentioned, there are also departments that look at various things that the planning department doesn't look at. For example, the building code on site looks at to make sure things are safe. So thus their requirements to get rails in on private property. And so there are provisions in place to protect falls already that apply.
Well, as a citizen of the city and as a pedestrian myself, occasionally that's a concern of mine. So that's when someone applies a variance, I can see all the reasons for a variance, but I know what can happen. And so that's why I bring these things up, is because I'm a citizen too, and I want to make sure you may have a department that says it's safe, but I've heard of other situations where things were considered safe and they weren't.
What I'm saying is the places where it exceeds our fence height requirement of 3.5 feet already has a barrier up. So what is your nexus if you're concerned about the
What
places?
do you mean by nexus?
What is the relationship?
Connection.
What's the connection between our approval criteria and places where there are no barrier? If in the places where you're getting a variance approval, it's already has a guardrail in that location. So is there a guardrail in the location where you're granting a variance? If so, then
Is there a guardrail right now? I haven't been through it this week.
yeah, the applicant can talk a little bit more about it.
Only because, again, they can have a guardrail in place, but we've had several hearings here before where somebody put something in without getting approval, and then you've had them remove it.
Yeah,
That's
so
what we're-
I'd recommend you talk to the applicant.
All right, I'm just concerned.
That's what we're covering.
Mike,
Okay, are there other questions for staff now?
One small one.
Yes.
Okay, since there's stairs coming off the public sidewalk, it implies that it is a walkway for the public and not for mechanical access. My question is, the corner, is there a minimum width for a sidewalk down below, next to the
For the
building?
walkway.
Yeah, width.
So our pedestrian, that's another good question. Our pedestrian circulation requirements
Yes.
are for building entrances to be connected to the street and different entrances on the site to be connected to each other. And the
Yes.
minimum width for that is 5 feet.
Okay, because it's not
so-
5 feet.
Right, so
It's 3.
the 5-foot walkway that they have that meets the code
Yeah.
is this one right here,
Okay,
going to the entrance.
okay,
This walkway is an additional walkway that isn't technically required, and so the 5-foot minimum doesn't apply to that.
But it's a
Okay.
sidewalk.
okay, because I wasn't sure if a stroller or something long
Right.
would be able to get through there with that.
Right, so
But it's a sidewalk,
so
it's a sidewalk.
this is, there are no stairs for this
Okay.
This right here is a
route, and that one is 5 feet wide.
Okay, but since the other one comes from the stairs, it doesn't really matter if, you can get a wheelchair over there, because they're not going down to, hopefully,
Hopefully
They're not going down the stairs.
Yeah,
okay, all right, that was my question, thank you.
yeah.
Okay, any other questions for staff?
And,
All right.
Mike, I haven't received an email from you.
I sent it to Laura.
Oh, okay.
Should I send it? I can send it to
Can
you.
you send it to me, please?
Yeah.
Have to meet. So I think that would be a code.
Okay, then at this time, we'll hear from the applicant for a 15-minute presentation. Or you feel free to take less.
I'm learning that.
Has to be 15.
I can talk for 15 minutes.
You won't have to.
I
I'm
received
probably not on this issue.
Okay, my name is Stuart Strauss. I am the architect for the project. I work in Beaverton. I had come in here thinking that all I was going to have to say is that I agree with the staff report and ask for questions. The questions are already out there. I'll do what I can to respond to them. As mentioned, this wall is essentially a below public sidewalk wall, and the guardrail that is provided is intended to provide the safety that is required for changes in grade that exceed 2 feet as part of building code. And it extends for that portion of the wall that is greater than 2 feet high. So in terms of building code, we are in compliance, and because this is on our site, not in public right-of-way, the wall and the guardrail, those are the criteria that we're obligated to meet. The space between the wall and the sidewalk, generally speaking, is not sloped. If it's sloped very minor until we get up on the Malala Avenue portion of the wall, where the wall moves further away from the sidewalk and there's a bit more slope in the ground. There's also a much wider sidewalk at that location at that point, the landscape area is not much different than you might find on any other site that abuts a public sidewalk. Those areas are landscaped with plants and other ground cover. It's not lawn. In fact, I don't think we have lawn anywhere on our landscape plan on this project. The landscape materials are generally on the smaller side in those areas because the space available is small, but they are an additional visual and tactile message to pedestrians that there is something going on that they need to be careful of. In terms of the visibility coming around the corner, the sidewalk along Malala is typically quite large, and the vehicles are away from the pedestrians that might...
Sorry, do you need the diagram?
No, I'm fine.
Please leave it
I'm
up though.
pulling
I've
up
got
the
questions.
photo, and while I do that, I didn't want to distract you all with.
No, that's fine. The visual clearance to the corner is not impaired at all by the railing. The railing is far enough away from the travel lanes in the street that it's not going to present an obstruction for cars on Malala. And as they're turning their corner onto Warner Mill, if there are people on the sidewalk as pedestrians, I don't see where there would be an obstruction that would keep them from, if they are aware, as they should be driving, that they would see anybody on the sidewalk. I can understand your concern with all the what-if issues that might occur in a situation like this. We go through an evaluation process as part of our design. We just don't throw these things together. And, there comes a point where we feel that we have been responsible and prudent in the way we have approached a solution to a problem. And as far as I can tell, and I've been doing this for a long time, we have a situation here that should be safe for pedestrians, their strollers, their wheelchairs, their whatever. We also have to rely on people being responsible as pedestrians or cyclists, just as much as they need to rely on what we do being responsible as well.
I agree with that. Are you open for questions?
Oh, of
Or is
course.
that
Anything else
finished?
Anything else you wanted to present, or are you ready for questions?
I'm ready for questions at this point.
Okay.
Can you take it back to that slide you had up there, the corner and the Right. So another question I have, you almost hear about it every week. You're at a corner of an intersection, and it seems, it's not just elderly, it's anybody, step on the wrong gas. I'm looking at pipes, and I'm going, okay, so somebody has an accident at an intersection, they push a car, and it goes through pipes that don't look very sturdy to me.
What-
That you got pipes here for the wall. I was gonna ask if they were slats or pipes. What's to stop a car from going right through those down into the medical building right there on the
Well,
corner?
nothing any different than any other site in the city of Oregon City
Yeah.
or any other city around.
I know, it's
You
just
know,
that
I
those
mean,
don't look very
if
sturdy.
If we are gonna design projects, or if projects need to be designed to account for those kinds of circumstances, we would end up with major barriers to buildings like you see at a federal building, every single corner in the city.
I
You know,
agree,
mean,
I understand that.
You know, we don't design for every possible occurrence of somebody being irresponsible as a driver, or even making mistakes or whatever.
My concern is your building is below the street level so that anything could happen.
It wouldn't matter if this building was at street level and there was no guardrail and no retaining wall, you could have exactly the same thing happen and the car will go right into the corner of the building.
What's to have prevented you from putting like those yellow ones you see at the federal buildings you referred to that went deep into your cement wall that was existing? Just two of them there to stop maybe.
But why not do that at every single intersection in the city?
Because not all buildings are below the sidewalk at all those
It
intersections.
wouldn't matter. It's the fact that it's below the sidewalk has nothing to do with what a car is doing in the public right of way. Every building in the city that is on a corner should have the guards that you're talking about if you want to prevent the problem of somebody driving into a building at a corner. The fact that we've got the building sitting down from the street level doesn't make it more likely to be a target, or might more likely to be a situation where you'd have a mishap with a driver. If you want to put something in your code that says that every corner site in the city of Oregon City needs to have guards to keep errant drivers from crashing into buildings that are at the corner, then by all means do it. And the next time I do a building in Oregon City, I'll make sure that I provide that.
The
But right
difference
now,
is-
that's not part of your code.
The difference is that it's below accidents or accidents. That's why they call them
Okay,
accidents.
we're outside the matter that's before us.
No, it's actually involved in it.
Oh, my-
I won't
Well,
go
it's
for
not-
anything like this.
There's,
Mike, I got a question. As
Yeah.
soon as you two.
Go ahead.
Hash there. Carrie, that's you? Okay,
That's me.
here it comes.
All right.
All right. Are we mixing apples and oranges here? I mean, what they're talking about is a city responsibility for safety at an intersection instead of the applicant. Now, I ask that in the legal sense. The city has a legal responsibility to evaluate the possibility of a dangerous intersection and take the necessary precautions to improve it. That's the city's responsibility, is it not?
The city's responsibility is the right of way. And that would be the sidewalk, the road, and making sure that cars can turn safely. And that's part of the development services building review that the city goes through when it reviews these applications.
Okay,
No part of this railing is in the right of way.
excuse me.
can you identify yourself?
I'm sorry, I'm
please?
Jeff Crone. I'm the project manager for the builder for this project with Joseph Hughes. I live in Portland, Oregon. But I was saying that now, no part of this wall or its footing or its railing is within the public right of way. It's all on private property.
Well, here we go again. I understand Tom and his concerns, but
I
Tom,
know,
I disagree with you.
but accidents are accidents. and
That's true,
You see it
but
on the
we
news
can
all the
have an
time.
accident down at Beaver Creek Road too.
Yeah.
Are we gonna blame it on this intersection?
But that's why they're changing all of the law to make it safer for pedestrians and bikers. I don't see a bike lane at that. There might be
Well,
there.
this has got.
There is a bike lane.
Is there? I'm
that's-
just saying.
I know what you're just saying. Let me just say too.
Go ahead.
Okay, Laura laid it on the table here. We've got to consider the application in terms of the variance standards.
I understand that.
Okay.
I'm also looking at
I don't think the variance
safety.
standards apply to what the design proposal is.
They thought Mitchell Corner was safe, and now they've had to put lights and everything
Okay,
there.
we're off the track here.
responsibility.
No, it's saying safety in the city. Things are out of control on drivers.
Mike?
Vern,
Don't outlaw driving. That will solve the whole
People are pretty
problem.
ignorant when they come to driving and they're
Okay.
driving faster.
I think that, I'm gonna focus on the guardrail for a moment. And I don't believe the guardrail is put there to stop any semis, trucks, or vehicles. It's there for the stated purpose in the applicant's narrative that it is an aid to helping from people falling over that wall, which is very close to the sidewalk, and 5-foot drop to cement. I know what happens when, it didn't happen in any place like that, but those things are what I think the guardrail is addressing.
Understandable.
And therefore, I believe it's what our decision is on a variance to construct it this way. We're not preparing for 18-wheelers coming around that corner at 30 miles an hour and try to stop it.
Well, centrifugal force should take them away from the guardrail, not towards it.
How wide are the pipes?
Well,
Okay, those are half-inch square steel bars spaced 4 inches clear, which is the required spacing according to the building code.
I think it's important to note that the railing meets building code, the wall meets building code, the placement of the wall, setback of the wall, all of that meets code. We are in compliance. The only thing that we're asking variance for is the height of the wall itself. It has nothing really to do with the guardrail or the placement of it or anything of that nature. It is only a variance of 1.5 feet of the wall. And we're asking permission to build it 1.5 feet higher than normal, just because of the site conditions required it.
Isn't the 5 feet part of a wall and then that's additional to it? Isn't 5
Yeah.
feet and then that's an additional
So
3, 8
if you
feet?
consider the guardrail a fence or wall, which I think would be reasonable to consider the guardrail also a fence, then it would be 8.5 feet total.
Yep,
With
that's what I'm
3.5 feet being above grade, which 3.5 feet is the normal height
So it's not just
limit.
a 1.5 feet.
You know, I think if you could probably interpret it either way, say the guardrail is a guardrail, it's for safety,
Right.
it's not a fence. But I think for the purposes of this, we are including it in the overall variance. And we still have the same recommendation for approval.
And the other question I had originally was where does the stormwater go off sidewalks? There.
It slopes towards the street.
It goes to the streets. The sidewalk
On the
is not
public
that.
sidewalk, it slopes towards the street.
In the landscape areas, it's collected by a perforated drain pipe that runs behind the wall with drain rock all around it and goes into the storm water sewer system.
And all the on-site walkways are pervious concrete with drain system underneath.
I want to explain, I don't mean to challenge you guys, but I'm a kind of a devil's advocate when it comes to safety and
Never
these
would
kind of
have
things.
guessed.
Someone has to be.
And since we wanted to make sure the applicant got a chance to respond to this photo, I'll bring it up now.
Is that the photo you took? Mike?
yeah. And it isn't, I don't think it's a part of this variance request.
No.
It was more along the line, just a question I had was, is that sort of a situation covered where there's a drop off away from the public sidewalk? And when would you have to have a guardrail next to that sidewalk?
Okay, you would need a guardrail if you have a drop of 2 feet or more immediately adjacent to a pedestrian walkway. Here we have a gently sloped grade from the public sidewalk that's also going to be planted fairly heavily, and there is no nobody's gonna fall off the side. You know, I mean, if somebody, we've got landscaping all the way up to the sidewalk. If somebody is walking, you could have that slope and that landscaping on any project that's built in a city that would be considered a normal, reasonable adjoining condition to a public sidewalk.
Okay.
And, you know, there's no particular reason that it would be questioned.
So you call the area patio that goes around here?
Well, I don't know, you want to explain that one?
And is that the door right there where that word patio is?
The door is opposite the patio on the south
Right
side there.
Because I didn't see one
Yeah,
over there.
we don't show the doors on the landscape plan, which this is, but we had a connection to the street originally opposite those doors at the patio on the south side. And because of the change in grade, we had to abandon that access to the building. And as part of the trade-off that we worked out with Kelly and the other staff at the city, we added the connection out to Malala Avenue further north and provided an outdoor area that people could, the low part of the wall that we're building, that you saw in the photograph, is going to be able to function as a bench for people to sit and, yeah, that area.
Can I ask what those fluffy cloud type things were? There was two of them on there.
Those are delta changes. Those are
That fluffy
referencing
one
the
there in
change.
Oh, yeah.
They're what?
They identify what was changed from a previous iteration of the
I see,
drawing.
okay. I thought they had clouds in there.
No, it's always sunny in Oregon City.
Unless it isn't.
Do we have other questions for the applicant? Okay, thank you. Sure. At this point, we'll close the public hearing and we will deliberate. Comments, questions, concerns?
I don't have any concerns with this. I think it's just a housekeeping problem. I'm gonna support it.
Voiced my concerns, I won't support it. I'm still concerned about safety on that corner.
Seems simple enough.
Okay, Patty?
I'm for it.
Okay, it comes back to common sense a little bit. We have that height restriction in the code so that we don't bury buildings behind big walls. That's not the case here because it's going the other direction, so I have no problem with it either. Anyone care to make a motion?
I move to approve GLUA-19-19-00020, comma, 19 dash, or SP-19-0074, comma, variance dash 19 dash quadruple zero. Okay, good.
Is there a second?
I'll second.
Okay.
Third.
Moved by Commissioner Mahoney, second by Commissioner Johnson. Any other comment before we move to the vote? Okay, call a roll, please.
Commissioner Gao,
As usual, I stand alone. No.
Commissioner Schlagenhofer,
Aye.
Commissioner Gage,
Aye.
Commissioner Stoll,
Aye.
Commissioner Johnson,
Aye.
Commissioner Mahoney,
Aye.
and Chair Mitchell.
Aye.
I stand my ground.
Thank you very much.
Thank you.
All right, we'll move on to item 3B. Code amendments to Historic Review Board policies and procedures. Sorry, that's my work background. Anytime I see HR, human resources. Sorry. Okay, Historic Review Board. Kelly, are you up again?
I am.
Okay.
Thank you, Chair Mitchell. We have a legislative amendment to Chapter 1740, the Historic Overlay Chapter. This amendment was initiated by staff. It wasn't an application from someone outside of the city. So before I get into what the amendment is, I just want to give you a little bit of background on how a historic review process works so that this makes sense. So the historic review chapter applies to both alterations to existing historic structures or properties, and then also new construction within the district. So first I'll talk about the new construction. We have McLaughlin District and Kenema District. When, vacant property is developed or, property is redeveloped with a new building, or if an existing building, even if it's not a historic structure, wants to build an addition that's 30% or greater in size of the original structure, we consider that new construction. And we have a whole set of design guidelines that applies to new construction. So if somebody wants to build a new home in Kenema, they go through that process. They use the design guidelines, and the review is a type 3 review by the Historic Review Board. No changes are proposed to those design guidelines. So moving over to alterations to existing historic resources. This includes any exterior alterations to an existing historic property, including additions that are less than 30% of the original size of the structure. We have a separate set of design guidelines for alterations that we use to review these projects. No changes are proposed to those guidelines. Now, those are reviewed as a type 3 process as well by the Historic Review Board, unless the project falls under the HRB policies. So the HRB policies essentially are a list of things that meet the design guidelines for alterations. The board has said, if you want to do these things, we've already determined that those meet the design guidelines, therefore you don't have to put in an application to us and have us review it. We've already determined that this meets the design guidelines, so staff can just look at it and say, okay. So that's what the HRB policies are for, and those are type 1 review. So the code amendments are related to these HRB policies. Now,
So, excuse me, only an alteration can fall under HRB policies. If
That's
it's
right.
new construction or greater than 30%, it's always type 3.
mm-hmm.
Okay, thank you.
So 1740 was written a long time ago, and it hasn't really been amended in a long time. And it discusses the HRB policies in 2 separate sections. Those 2 sections actually conflict with each other, we realized. So we are in the process of updating the HRB policies, and when we took a look at the code, we realized that we have this conflicting issue, and we'd like to clean it up while we're updating the policies. So the current code kind of talks about work that meets the HRB policies can be approved at through an administrative process. And the HRB policies can pertain to, and there's a list that begins, and then it just ends with any policies adopted by the HRB. And then there's a separate section that says for administrative review or work that meets the HRB policies, you have to do public notice, and then to everyone within 300 feet. And then if anyone requests a hearing within 10 days of receiving that notice, then you have to have a hearing. If no one requests it, then no hearing and it's approved. So that's the part of our code that we haven't actually been using. And we may have used that long ago, but nobody who works at the city can remember when we last ever used that process. So that's the part of the code that we would like to strike, that we don't use that sort of procedure for anything else, for planning commission, for anything that comes before planning commission or for historic review board. In addition to that, the policies are written by the historic review board so that they are clear and objective. So, a hearing, when policies are clear and objective, we can look at the window and say, yes, that's a wood window, it's not a vinyl window. It meets the policies. So a hearing wouldn't change the outcome of that. So a hearing just kind of adds unnecessary, or notice and a hearing adds a lot of unnecessary process for an item that's clear and objective and has already, been decided. So the amendments strike that section and then clarify that it's an administrative staff review, that the policies are clear and objective, and that the HRB can update its policies at any time with comment from the planning commission and the city commission, which is kind of what we've been doing for the past few months.
Before you move off that slide, I just want some clarification on it. So if somebody came in, let's say in the Kanema neighborhood, and wanted to contest something, right now it says that they can do it if they, 10 days after they receive a notice? And you're saying that's not needed, it's never been used?
So there's a section of our code that says, if you have a proposal that meets the HRB policies, you have to put out a public notice. Well, so there's one section that says it's staff review, right? No public notice, no hearing. And then there's another section that conflicts with that, and it says, put out a public notice. If anyone within 10 days of receiving the notice requests a hearing, then you have to hold a hearing.
We'd hear from a lot of people in Kanema who want to have a hearing on everything.
Yeah, and well, I mean, the issue with that is that someone wants to build a white picket fence, that meets the HRB policies. We put out the notice, a hearing is requested, and the board says, well, it meets the policies. Why did we have this hearing? What's the purpose of this? So really, we don't want to waste people's time, and two, we don't want to give people false hope that when they receive a public notice, they can actually influence something when really they can't, because it's totally black and white. So when we give people public notices, it's when there's more discretion involved and we want public input. And we're doing, for the HRB policies, the public input happens when the policies are written. Once they're written and adopted, that's what they are.
You just have to make that really clear to, there's a lot of neighbors in Kanema who get really upset if they feel their voices aren't heard, whether it's in the policy or not,
Right.
They're gonna come in and tell you, we weren't informed and we didn't have a chance to make a comment, even though it's in the policies.
Right,
That's
right.
just some neighbors.
Yeah. So I can explain a little bit more about the policies, but really, that's what the code amendment is.
Well, I understand, I'm just
Yeah.
saying, how it goes.
Yeah. So we're working on the policy updates, which has gone through a large public process. There's actually a meeting tomorrow of the Historic Review Board to adopt the final version of the new policies. City Commission would adopt that by resolution on August 7th. And then this amendment to 1740, if it's approved, if the Planning Commission recommends approval tonight, it would go to the City Commission in August for first and second reading of the ordinance.
Are you using the word policy with the word standard? Are they both the same?
I would say yes, you could consider it a standard. It is not codified, so it's not in the municipal code. But the municipal code says the HRB may adopt its own policies for alterations to historic structures. And so the word policies is in the code, that's why we're calling them HRB policies. And they essentially act as code. One thing to know is that if someone wants to do something that is not within the purview of the HRB policies, they always have the option of submitting an application to the Historic Review Board. Or if they disagree with, staff, say, if I say, no, that doesn't meet the policies, and they disagree with me, they can still apply to the Historic Review Board, and then they have the option to appeal any HRB decision as well. So there's recourse for people.
So based on Bob's question, to clarify, so HRB has its own policies and they're not included in the code.
Correct.
Where are those policies located if somebody wanted to go look at the policies?
They're on our website and in our office, and
Okay.
we send them to every historic property owner. When somebody new moves into a historic
That's good.
home, we send them by mail.
Okay.
Carrie, can a policy stand on its own without being part of the code?
That's what I was wondering.
Yes,
It can?
It can.
Isn't it subject to,
Because it is part of the code, because these code amendments say that the HRB will adopt these policies. These policies are essentially sort of de minimis exceptions, right? De minimis exceptions to type 3 review. Because the proposal is so clear and objective that that the HRB has deferred that to staff. And so the code says there will be policies. That's what puts people on notice that there are these policies, and then they go and find them.
So the policies are sent out to you on like a postcard, you say, here's some policies, go look them up?
We've actually sent out, so they're not all that long, so we've sent out hard copies of
Like an
the actual
HOA.
policies to folks. We get information from the tax assessor for property sales, so we know when someone new moves in each quarter. And we send those out, and then we also do a lot of other outreach to try and get the word out so that so people know about the policies.
That's
Yeah.
good to hear. The one concern I've heard from some, on our HOA, and I've heard it from others, is that so many of these don't even know what they're signing when they buy a house, and all of a sudden they get this notice, hey, there's policies. Well, I didn't know about these ahead of time. I got them after I moved in.
The other thing to respond to your concern, Commissioner Mahoney, the design guidelines aren't part of the code either. I'm just saying they're not part of the code, but but compliance is required by the code. And that is the hook that binds people to comply.
In other words, the code authorizes them.
Correct. So the proposed language here is the following exterior alterations to historic sites shall be subject to administrative approval. A, work that conforms to the adopted historic review board policies.
What's she looking at? Oh,
what
there
I'm
it is.
getting at is if can the policies be vague?
No, that's why they're gonna be clear and objective.
Okay,
And the policies, Kelly can summarize them better than I can, but they're things like the window shall be made of wood. The window can't be made of vinyl. The window has to have a certain size of glass.
well, why can't that be written down?
Well, it could be part of the code if
I
the
mean,
city decided that it wanted it to be.
But what, instead of written down, I mean, why can't it be part of the code if it's that important?
In detail, yeah.
It could be, but it would take more, amending the policies then would take a legislative action.
Well, I just want to ensure that everybody gets fair treatment, and party A knows what party B is
Yep.
the same as party B. They still get the same answer, and it's uniformly applied, and it applies to all. And a policy to me sounds like it's kind of an understood.
Well, I would urge you to look at the policies themselves, because I've worked pretty hard with staff to make them clear and
you're satisfied-
objective.
you're
I'm
satisfied.
satisfied that they're clear and objective.
From a legal standpoint, we're on
Correct.
solid ground.
And you, the planning commission had a presentation on the HRB policies last month or the month before as well. But it is our tool to provide clear guidance for people so they don't have to pay the money and go before a historic review board for something that is not discretionary.
If a property changes hands, would the existence of those policies be something that would be turned up in the title insurance report?
No.
No.
But neither would the zoning,
Okay.
neither would.
Yeah, okay, I was asking.
In a title reports now say, has to do with title only, the validity of title only, and if you want to know more about land use, go speak to the city planners.
Okay, just
That's
curious.
a disclosure under state law.
The reason I brought that up is 90% of the problems we get ourselves involved in has to do with communication and a misunderstanding of 7 different people up here that have to make a decision within 30 minutes. And of course, we rely on the staff report that's dealt with this application for 3 weeks. You see, but if we've got a clear understanding of what the standard is, then we know what we're dealing with, and all 7 of us know what we're dealing with. And when you get into this vague stuff, and, it has a tendency to slide on you.
Well, I mean, certainly look at the code right now. I mean, we've got contradictory provisions
Yeah.
about how to do this. I mean, talk about vague stuff. We need this code amendment to clear up the contradictions and procedures that exist now.
Yeah, and I agree with what you're trying to do.
Everybody take note, Bob and I are in agreement right now.
So Bob's question leads me to another question. In what we do, what the Historic Review Board does never comes before us.
Correct.
They're doing their own deal.
Correct.
In what we do, we don't have any policies like this that are not in the code. Everything we rely on is in the code. Perfect. Then we have to figure out what it means, but at least it's in there.
Well, you all have clear and objectives, there are clear and objective site plan standards that don't come before you, right? They get reviewed by staff at a staff level and you don't see it unless it gets appealed.
Right.
Well, even in that case, unless it's a type 3, sorry. So, you don't, and the reason why Historic Review Board has these policies and these design guidelines is because historic review in the olden days was viewed as separate from land use. It didn't evolve in the same land use world as land use planning. It was a separate track. And so this is an effort to sort of merge this separate track with land use planning in a way that doesn't take a whole bunch of time. I mean, because you're right, Bob, we could codify design guidelines and policies and all this stuff, but that would take time and resources that we can't prioritize right now.
Well, look at the hundreds of thousands, well, tens of thousands of dollars this city has spent just on the interpretation of a word. I want to get away from that. My God, Austin, to take things to court and the Court of Appeals and then LUBA and, it's just.
So we're trying to, I think, sort of smooth out the edges without messing with the guts to the extent we can, right? I mean,
Yes, we're just removing the conflict. We are not touching anything else that may or may not be right or wrong with the Historic Review Board
We've lost
requirements.
one important element in this whole thing over the last 50 years. At the end of that standard, there's a person that's going to be affected by that standard. And we got to keep that in mind, But we're here to serve. We're not here to serve the standard. We're here to serve the public.
That's why we like this, is because right now the code says to process the same thing 2 different ways, and that's confusing for people.
Keep it simple.
Yep.
Kelly, in looking at it from a board, Historic Review Board, are we limiting anything that they can do by eliminating one of these things? Or is it just a different way to approach it? And they still have the same power and process to do their job? We're not limiting anything, I don't think, are we?
No, so the way that they adopt the policies is staying the same. So they can adopt the policies with public input, planning commission comment, city commission comment. And then again, if someone disputes, the staff decision or wants to submit their project to the board for whatever reason instead of to staff, they can pay the $50 review fee and submit it to the board. The board also, they can change the policies at any time, through that public process.
So we're not taking anything away from HRV, or HR
No.
review? Okay.
Kelly, did you have anything else?
Nothing else.
Okay, any other questions? No? All right. Communications.
Oh,
are we gonna have
you vote, motion? A vote.
To do what?
This is a legislative file, so we're looking for a recommendation of the city commission on on these specific red lines, for how we process Historic Review Board policies.
I recommend, do I need to make it a motion? Or just? I'm trying to move this up to get the top of it so I can see what it is. But that's your screen.
I don't see it.
The file number is Galua 19-00022.
Yes, what she just said, I moved to approve it.
Recommend approval by the city commission.
But it's-
So we're recommending that the city commission approve this
These
file.
code amendments,
That's what you wanna do.
if that's what you want to do.
Okay,
Yes,
that's
okay.
what the motion,
Yes.
That's what I meant to say almost.
got it, okay? Second? Sorry, okay, seconded by Commissioner Stoll.
All right.
Other questions, comments? Okay, vote?
Commissioner Mahoney,
Aye.
Commissioner Johnson,
Aye.
Commissioner Stoll,
Aye.
Commissioner Gage,
Aye.
Commissioner Schlangenhofer,
Aye.
and Commissioner Guile.
Let's see, yeah. Aye.
Chair Mitchell.
Aye. Okay, now communications.
I wanted to thank you for your service to the city and volunteering. We really appreciate, being a planning commissioner is notorious for being hard work and taking lots of time and lots of reading to read very thick packets of code language, and it's not easy, and we appreciate that you guys do it, and you do it well, and you show up every meeting, which can be frequent. We have a lot of meetings.
Which are relief.
So I wanted to thank you for that and then invite you to a volunteer appreciation. You should receive cards before you for your ticket. But thank you very much. We really appreciate we really, really do. We can't do this without you. The public process is, as you know, is a large part of, yes, that's the ticket.
So this is it?
That's it.
We get a reserved parking space for
That's what I
8
thought.
years of volunteer service?
And food.
Eat a lunch.
Get a dinner.
Yeah, you get a
You
dinner.
get to bring
Is
partners
that-
and
Yeah,
wives.
you get a free dinner.
There might be a little condition on the reserved parking spot. If you get there early
Oh.
enough, it'll
You have to be there by 4:30 the way that
Is,
Hard to lately.
is that tonight the Kardashians, at their, the program starts?
You're close.
Okay.
But we really do. We appreciate you guys taking the time to commit to the betterment of the city and to make sure that we have public involvement, to make sure that we are processing applications appropriately. So thank you for that.
So you guys don't supply the lawn chairs, we have to bring our own?
We have
I
the
love that
food,
look in your
the
eyes.
food.
You try to give people something for free. and then, what
Yeah,
about
there's
this?
dessert.
Optimists are gonna hurt that night.
Anything else?
That's all. Thank
All right,
you.
we're adjourned.
Thank you.
Thank you.
Just in
Thank you,
time.
everybody.
Thank you. Yeah, so the whole parking lot's reserved for volunteers, but you can